Committee this Wednesday afternoon, May 13th. And we are going to be looking at S12, the Sealy bill. And Marshall Paul, if you could join us and weigh in on the latest version here.
Thank you. I'm Marshall Paul from the Office of the Defender General. So I'm weighing in on and I think I've testified about most of this, so I'm going to focus my testimony on the change on page 26, which allows for access to sealed records by a defense attorney who may use sealed records, use sealed criminal history records in representing a defendant. We are glad to have that in there because the bill, as it was drafted before, created a real inequity in terms of how these could be used. We still have concerns about this provision because it doesn't provide nearly as much guidance as the similar provision that provides access to law enforcement agencies, which include prosecutors' offices, law enforcement officers, law enforcement agencies. So the concerns that I have in particular are around what does it mean to use a criminal history record in representing a defendant. So for example, the things that come up for me, which this provides me without guidance about, are can I, for example, share a sealed criminal history record with an expert witness who I'm working on, who I have involved in a case? If I can share it with an expert witness, can I share it with a lay witness who I might be preparing to testify, who I might want to prepare to testify in connection with the sealed record? I might want to say something like, for example, if you knew that this person had a sealed record of such and such, would you have reacted in a way that you did, or something like that? So this idea of use, which this allows, is just so undefined that it doesn't tell us what we can and can't do. And part of the problem with that is the consequences for getting it wrong. Because if you use it in a way that, because the word use is not defined in here, if you do something that a judge finds falls outside of the word use, then you're subject to $1,000 fine. So it's a pretty hefty, it's not something that anybody's going to want to take a gamble on. Like when I have my first case where I'm doing a deposition and it makes sense for me to ask a witness about a sealed record, I'm not going to do that because I'm going to be sitting there saying, well, I haven't seen any decision from any judge saying I can do that. And I don't want to be the first one testing that out with $1,000 civil fine and my law license on the line. So what we would want is something that's more clear about how it can be used. And we would want that to be the same between the defense and the prosecution. So I think that the criminal justice purposes definition is pretty expansive, and some parts of it don't apply in the same way to defense attorneys as they do to criminal justice agencies. I think that definition was lifted out of a section that really has nothing to do with expungement and sealing. And that's one of my concerns whenever we do that, whenever we lift definitions out of one section and apply them to another section, because they're really crafted with the section they're written for in mind. And this one was crafted not to deal with these issues. And so from my perspective, what would be better would be to write a definition that specifically addresses how anybody who's involved in prosecution or defense can use sealed records, and just make those rules consistent, make it the same rules for everybody, write it in such a way that it applies to everybody. And then you can just have the same rules for everyone. And you don't have to have, one set of rules for one group and one set of rules for another group. Another concern about that is this is limited to a defense attorney. And constitutionally speaking, that's going to cause problems when you get into pro se litigants, because we have constitutional law that says that you can't deny a pro se litigant resources or procedures that would be available to a defense attorney. People have a constitutional right to represent themselves pro se. And so the way that this one's written would really only allow defense attorneys to access sealed records, not pro se litigants. Now, that might seem like a small thing because there's a pretty small number of pro se litigants, but I would say that not accounting for pro se litigants is always a mistake, even though pro se litigants make up a pretty small part of a caseload in court. When it comes to the amount of time and energy that they take up from the judiciary and prosecutors' offices, it's a lot. Pro se litigants tend to be very litigious, tend to definitely pick up on things like if there's a law that, does not allow them to have access to something that the prosecutor's office has access to. And so while it's a small group of people, it is, in terms of resources, a very important group of people. And we got to make sure that we're giving pro se litigants the same resources that represented litigants are entitled to. The only other thing I would say, and this is just sort of shifting off of that topic and just to some other changes that I've seen since I testified about this bill last, is on the page before. So I was talking about page 26, 2 pages before. On page 24 is the change that was made to allow the petitioner to identify other entities that may have a record that should be sealed. And I just want to highlight that raises some concerns. I understand the reason for that, and I'm actually very sympathetic to the reason for that. But to me, it just highlights the problem, which is that under our current system where records are actually expunged, when a record's deleted, a record's deleted. When, as state agencies, when we receive an expungement order, we know what to do with that. I think this is already anticipating the fact that state agencies are not going to know what to do with sealing orders, and we're anticipating that they're not going to comply. This whole idea of telling people, you know what, even though state agencies are going to be told to seal your orders, we're also putting on you the responsibility to sort of identify which state agencies might have your orders or your records and, notify them so that they can have notice to seal them. Really just shifts the burden from the people who have the records to the people who are the subject of the records to kind of be responsible for tracking that. And that really raises a few concerns for me, one of which is, honestly, one of my concerns throughout, since we started talking about it, sealing and expungement probably 8 years ago, has been a thing I always raise and never seems to get much of a reaction, which is that we talk about sealing and expungement, and there's actually a lot of agreement in terms of the purposes and the reasons behind sealing and expungement. There's a lot of disagreement around the procedures around sealing and expungement. But what we don't actually talk a lot about is maybe we should be more proactive about not creating records that create these kind of problems in the first place. And that was, when we were recently, our office was doing its big transition from one case management system to another, and we were doing some consulting with cybersecurity people. Part of what they were telling us was it's not about protecting the information that you're now storing in the cloud. It's about choosing what information you keep in the first place, because this stuff is all vulnerable. No matter what you do to protect your information, until you actually delete it or destroy it, it is vulnerable. And so some of this, when we talk about sealing, we're getting grayer and grayer in terms of what does it actually mean? What is it going to mean to seal a record? I think there's some examples where the law has just not kept up with the practice. And I think that as soon as we move to sealing, that's going to be where we're at. And so just one example of that I'd use and that I'd say we're going to run into various versions of, because we've had the same in the criminal rules. We've had criminal rule 32 has not changed since I started practicing law. So that's been on the books for a long time. And that deals in part with how we address pre-sentence investigations, which are one of the only parts in criminal court, the only documents that's actually considered truly confidential. And so we have a rule in the pre-sentence investigation laws that says that anyone who gets a copy of a pre-sentence investigation has to return that copy to the probation office, and that nobody can photocopy a pre-sentence investigation. Now, I have no idea what that rule means or how it makes sense today, because I don't get a physical copy of a pre-sentence investigation. I get it in my email. So I can't return it to anybody, because returning it to somebody would just be emailing it back to them. I've discovered that we are probably not complying with the rule, because even though I delete the email, after the case is closed, I delete the email that had the attachment. I just discovered that all those attachments continue to live on in an attachments folder somewhere. I'm assuming that's true actually probably for everybody in the system who are all subject to this law. And it's just one of those examples of a place where, we talk about keeping things confidential, but because we're now doing things electronically, we can't keep things confidential. And this is just going to be the same problem. When we move to a system where we're no longer deleting records and we are just saying, these records are still stored, they're still stored electronically, they're still searchable and accessible electronically. We're just going to try to control who has access to them. And we're going to open that access to a huge number of people. Anyone who's affiliated with a law enforcement agency, any defense attorney, presumably, though, again, from this language, it's hard to tell, anyone who's associated with a defense attorney, plus everyone who's included in those exceptions, plus then anyone who is able to access that information illegally, which there will be plenty of people able to do, are going to have access to that stuff. So we're just sort of expanding what access is available, but very dramatically. I mean, pretty incredibly.
Okay.
To follow up on, I agree. I feel like we're trying to find a balance here because I don't want records out everywhere, but I really want it to be around housing, education, work, like that kind of stuff to not have any access to, which I feel like this covers. But wouldn't that be the case for a lot of these offenses right now? Because they're not expungible or sealable right now. So I feel like I hear what you're saying, but the reality is that's true for a lot.
I agree. And that's why I would have suggested that, for a starting point for a bill to do what this bill did, which is to eliminate expungement and replace it with sealing. If you looked at last year's H762, which was introduced by Representatives Gosselin and not whether it was Burdett or Oliver, but it was Burdett or Oliver. That bill would have really expanded the scope of what can be sealed or expunged. This bill doesn't actually expand it very much. Expands it a tiny bit, but not very much. So, from our perspective, the change in terms of the scope of the bill is pretty small. The change in terms of what it does procedurally is really huge. Huge change procedurally, small change in terms of scope. H762 was a large change, both in terms of, really it was the same change in terms of procedure as this bill is, with a much larger change in scope.
So going back to your first point on the use and the concerns with respect to, so it seems to me that if you're using or disclosing the document for purposes of representing the defendant, then you're fine, because the unauthorized disclosure says somebody who knowingly accesses or discloses sealed criminal history record information without authorization. And it would seem, if you're using it in any of those examples that you mentioned, that is representing a defendant. Now, if you send it out to a news organization or something like that, are you really representing your defendant in that scenario? I would say that's a lot more questionable. But the examples you mentioned, it would seem to comply.
That's interesting. I mean, I did not expect that to be your response. I expected, for example, when I was mentioning that I'm not sure whether this would allow me to share information with a lay witness. To me, that's a pretty broad exception. If I can share this information with lay witnesses, that's certainly using it in representing a defendant.
Right.
It is allowing very broad access and dissemination. It's essentially unfettered access and dissemination. Which, if that's what the committee's intention is, then I get that. It's not, when I read this, it's not what I expected it to be. And so that's why I say there is a lack of clarity here. And even if it is that broad, I would appreciate it to be spelled out, because I certainly would not have anticipated that your response would have been, oh yeah, sharing it with lay witnesses is entirely what we expected this to be used for.
Right, I mean,
Um,
presumably, I would think that a defense counsel or any counsel, if they're having a lay witness, they're not gonna just email a sealed document so that it's out of their control. But if they're gonna, share it, so,
And that's where I think that some precision would really be important, because what this seems to say, so for example, the way that I read um, criminal justice purpose, the definition that's been sort of copied and pasted from Title 20 into here and is on page 2 of draft 3.1. I would certainly read that to allow prosecutors to email a record to a lay witness that they were preparing. Because from my perspective, that's part of the process of adjudication, is preparing your witnesses.
right,
And if I'm preparing my witnesses, I give them all the information that I may be using in the course of their cross or direct examination. And I would expect that prosecutors, in fact, I know prosecutors do the same when they're preparing their witnesses. So I mean, if you allow it to be shared with lay witnesses, then I think it's probably going to be shared by email. And that's again why I think that some specificity and one set of rules that's applicable to both prosecution and defense, that's specifically written for these purposes rather than being kind of boosted from Title 20 and not really being written for these purposes, would be more appropriate.
I see your point. Any suggestions on how to do that?
No, but I could certainly try to come up with some. I mean, I think what I would do is I would start by, and I think it would turn into a point of debate, because I would start by trying to come up with the question. I mean, because part of this is a policy question of how broadly does the committee want sealed records to be used? From my perspective, sealed records should not be used broadly. In fact, from my perspective, we should have expungement so that expunged records can't be used by either side. But to the extent that they're going to be used, how broadly they're used clearly is a matter of policy, and not one where, I mean, I'm obviously not sort of in tune with what the committee wants as far as the limits on dissemination. So I think it's really kind of up to the committee to define the scope of that. I'd be happy to draft something, but what I would draft would reflect my office's interest in this legislation.
True that. So, all right. So, I mean, I think that the main issue is not wanting broader public dissemination, and how one tries to capture that is the question. Because we want the defender and the prosecution to be able to use these records to represent or to represent or defend a defendant or prosecute. But the intention isn't that it gets into the hands of lay witnesses who don't have any restrictions on further dissemination. So, yeah, we need to think that over as far as how to capture it.
And I know, and this adds complication to the process, but in one of the places where we do disseminate confidential records to people who are not subject to court orders, lay witnesses, people, who organizationally are not subject to the jurisdiction of the court, is in juvenile court. And I don't want to suggest that you use it because A, I don't think it works very well in juvenile court, and B, it's again the problem of taking something that's intended for one purpose and moving it to somewhere else. But Title 33, Section 5117 is the section on confidentiality of juvenile court records. And that, I think, is a more sort of comprehensive, here's how you can and can't use and disseminate these records. And when you do disseminate a record to somebody who's not subject to the jurisdiction of the court, here's how they're instructed to keep the record confidential and the penalties for if they don't. And how that whole procedure has to work is laid out in 5117.
Okay, that was my next question, is what title is that? Remind me again.
33.
Yeah, because what kind of jumped out just thinking about this a little further is some sort of non-disclosure agreement, but it sounds like maybe we have equivalent language for juvenile confidentiality. So you can look at there.
I think that, the two places where we use this kind of confidential information and we do disseminate it around parties in the court are in juvenile court, so it's anything that's subject to 5117. And then the PSIs, which are, that process is outlined in criminal rule 32. And there may be a statute in Title 28 about PSIs as well, but I think it's whatever
This
this,
is what PSI stands for.
pre-sentence investigation.
Thanks. Question? Yeah.
Yeah, I guess with the language, I'm not sure if we've landed on Marshall's going to propose language or not.
No, I don't think it's, I mean, we'll look at both things.
Could the
You made a
language-
good point about that. but-
Yeah. Could the language be like, it's going to be on the attorney if they share it with someone else and then the disclosure happens from that person, that it's still going to be the attorney's responsibility? I feel like that would resolve a lot of this.
It would be a weird thing to do in terms of, for example, as a defense attorney, I'm often calling witnesses who are hostile to myself and my client, and they still have information that may be valuable, and it still may be valuable for me to share information regarding a sealed record, but it's somebody I truly don't have any control over. And in fact, even to get them on the stand, I have to subpoena them and have the judge declare them a hostile witness so that I can even.
But then that's I don't want to interrupt, I mean to interrupt. But isn't that the check then? So it's like, yeah, you don't email the record to someone you're going to probably have be a hostile witness. You talk to them about it, and like, you'll lay down the groundwork you need to. But like, it's like you're having the attorney thinking about, hey, how reliable is this person that they're going to comply with confidentiality requirements?
Again, I just don't think you can put that on the attorney. I think, so I recently did a lot of research into, because there's a rule of professional conduct that touches on something similar, which is non-lawyer legal assistance. So when you have a non-lawyer legal assistant working on a case as an attorney, you are responsible, I forgot, it's something like to a reasonable degree, to make sure that that non-lawyer reasonable legal assistant follows the rules of professional conduct that would apply to you as reasonably as possible. So even when you're talking about somebody who has a much closer connection to the defense attorney than, for example, a hostile witness, you're talking about my secretary or my legal assistant or my investigator, it still provides a lot of buffer where it's like, you're not really responsible for making sure that they don't screw up. So if they're given that much leeway, I mean, a hostile lay witness, you got to have a lot more leeway.
Yeah.
I don't think you can put it on an attorney to say you're responsible for controlling whether or not this hostile witness disseminates information that,
So, yeah, I was thinking of like the legal intern, like the third year law students and like the fourth year law
Certainly.
officer, where like they have, is it the same level of accountability? I feel like it's more like where.
right, and
Yeah,
from my perspective, those are non-lawyer legal assistants. We treat them that way, like in our office.
yeah,
We make them sign a confidentiality agreement, and actually, because they're all law students preparing to take the bar,
Yeah.
They can actually be subject to attorney discipline if they violate those confidentiality agreements. Even though they're not yet lawyers, they can be prevented from becoming lawyers by violating those
yeah. Okay.
rules. That obviously doesn't apply to people who don't have any connection to the legal system.
Other questions for Marshall? Or do you have any additional items? All right, so we have, let's look at this. Yeah, go ahead.
I have one other question. If we just, 26 again, if we just change it to, a defendant may, and then let's say
Where's this?
so on page 26, line 5, so I get the pro se issue, and just remove all the language after this. But if we started number 3 with a defendant may, use a sealed criminal history record as in a way as defined by blah, blah, would that just like cover it for you?
I think that would solve the issue with pro se litigants. Yeah, that would take care of that.
Okay.
That was a more elegant way of fixing that than what I had.
I went the other way and got clunky.
That did get a little, okay, yeah. All right, thank you very much.
Thank you.
So we don't have another witness until 3:15. I know we still have to talk a little bit about some of the other, I keep on forgetting that embezzlement crime, but I think we'll probably talk about that. We've scheduled an hour for this tomorrow morning as well, and also possible vote. And I think Tom wanted to be here for that discussion. So we're break until 3:10. I think our person may come a little bit early. We're going to hear from Aton on behalf of RDAP, the Racial Disparities Advisory Panel, about just how they're working or how things are working or not working as far as their legislative charge as far as working with the legislature. So we'll hear from him and then we'll be done.